Yes, good morning.
My lords, my lady, I appear for the appellant in this appeal, ABP Technology Ltd. My learned friend Mr. Brandreth appears for the respondents.
Yes. Mr. Akins, before we get into it, a couple of things. Firstly, you could take it that we've read the papers and we have a lively appreciation of the issues, so you can tailor your submissions accordingly. And secondly, we assume that you've spoken so as to divide up the time between you broadly equally. We've got half a day, so you'll doubtless bear that in mind. And Mr. Brandreth, you will, when you respond, you will leave time for Mr. Akins to reply. Yes.
Thank you, my lord. In this appeal, the appellant seeks to reverse the decision of Mr. Justice Miles to grant partial permission to the respondents to amend the defence and introduce a counterclaim 5 months after the original defence was served. I start by acknowledging up front that the judge's decision under appeal was a case management decision and one involving the exercise of discretion under CPR Part 17. And so, as is common ground, it is incumbent on me to show one or more of the following: that the judge did not apply the correct principles, that the judge took into account irrelevant matters, that the judge failed to take into account relevant matters, or that the decision was so plainly wrong that it exceeded the generous ambit within which reasonable disagreement is possible. Now, our case on this appeal is that the judge's decision suffers from each of those deficiencies. In summary, our case on appeal is as follows. The judge did not apply the principle that an amendment is late if it could have been made earlier. That is ground of appeal number 1. Secondly, the judge took into account an irrelevant matter, namely that the earlier stealth trademark, the subject of all the amendments, was at all times on the register of trademarks, such that the claimant could have applied to revoke it at any time. That is ground 2, and that concerns the point of policy as to whether a party should be under a duty to clear the register.
Yeah.
And thirdly, the judge failed to take into account a relevant matter, namely that the separation of beneficial and legal title to the earlier stealth mark was something that was a deliberate choice by the respondents and was used as a reason for delaying the amendment to their advantage. To the extent, therefore, that prejudice would be caused to the respondents if the amendment was refused, this had come about by the amending party's own conduct and was therefore a factor on which the respondents could not properly rely, according to the authorities.
No.
So that is ground 3. And while I stand by what is said about ground 4 in my written submissions, given the time available, we do not press that as a freestanding ground this morning.
No, my understanding was that 4 effectively, you say, came out of the first 3 points.
Yes, that's right. As I say, not a freestanding ground today. As to grounds 1 to 3, we acknowledge, as we must, that they overlap, both in terms of where we say the judge went wrong and the consequences that flowed from such errors. The exercise of discretion is, after all, a composite process. Ultimately, our submission is that if the judge had exercised his discretion correctly by applying the principles in the authorities and taking into account only relevant factors, then the amendment should have been refused altogether. And we do say that the effect of the judge's various errors taken together was that the judgment, insofar as it partially permitted the amendment, was plainly wrong. And that is primarily because it permitted the respondents to deploy the amendment procedure as a weapon in litigation. By deliberately delaying making amendments to their case, the respondent secured a significant advantage in the litigation by denying the appellant an opportunity to take action, the effect of which would be to deliver a knockout blow to the case as proposed to be amended. To be clear, and to answer one of the principal points made by my learned friend in his skeleton, this appeal is all about the amendment procedure. It is not about the fact that the respondents have gamed the system as set out in the Trademarks Act. If there was no application to amend the defence and introduce a counterclaim, then we would not be here today. And the oversight of the court over the respondents' actions is engaged not by the provisions of the Trademarks Act, although they provide the context and the prejudice, we say, but by the need to obtain the court's permission to amend one's case and the principles applying to the grant or refusal of that permission. So, my lords, my lady, with that introduction in mind, the course I propose to take in my submissions is as follows. First, I need to go through the key facts and dates relevant to this appeal, and I need to do that for three reasons. The first is that this appeal is all about timing. So what happened when is crucial to the analysis. Second, as Lord Justice Arnold said when granting permission to appeal, this is a very unusual case, and it was the unusual circumstances of the case that gave the appeal a real prospect of success. And the third reason is that there continue to be developments on the respondent's side, even in their appeal skeleton, in terms of what is common ground as to the factual and legal state of affairs at the key dates, and as a result the consequences of those developments for the exercise of the discretion to permit amendments. So then, secondly, having gone through the key facts and dates relevant to this appeal, I'll then flesh out our submissions on grounds of appeal 1 to 3.
I'm sure you'll take your own course in relation to that first element. As I say, do bear in mind that we have read the papers and
I'm grateful for that indication.
noted down what we think are the relevant facts and dates.
Thank you, my lord. If I am getting bogged down on matters that are well appreciated already, then please let me know. So first, I said there have been developments on the respondent side. The likely explanation for this is that the respondents, as ladyship will be aware, never served any evidence describing the history of the amendment or containing an explanation for the timing of the amendment. They simply relied in support of their application to amend on the draft amended defence and counterclaim itself. And neither did the respondents respond to any of the appellant's questions asked both in correspondence and its evidence about the facts as set out in the draft plea. In correspondence, they claimed that the questions were irrelevant, and we were then drip-fed information, first from my learned friend on his feet in the hearing before the judge, and now secondly, even in my learned friend's skeleton on appeal. This in itself, we say, is a failure to follow what the commentary in the White Book describes in the context of amendments to statements of case as the modern approach to litigation, which requires that the parties are open, above board, and cooperative. But in any event,
There has been a statement from Mr. Brownlow, but it's all about headsets and hi-fi apparatus.
That's right. So that is about...
So when you say there's no evidence that deals with the material points.
The history, specifically the history of the amendment. So all that statement does is it responds to one of the points that is not an issue on this appeal, which is that the amendments had no prospects of success.
Yes.
So just for your reference, the application notice is at supplemental bundle tab 3, page 48.
Yeah.
And then they just tick the box saying we rely on the statement of case. But yeah, so in any event, as I say, the overall direction of travel has been one of convergence in terms of common ground, as we shall see, between the parties. So there are 6 key dates. The first is issue of proceedings, 24th of November 2020. The particulars of claim are short, set out a straightforward claim for registered trademark infringement, reflecting the outcome of the proceedings in the IPO that by that stage had been completed. The appellant owned registered trademarks for Stealth and Stealth VR. The conduct complained of was the respondent's use of Stealth in relation to identical goods.
Just give me a moment. My lady doesn't have her authorities file, and I'm sure we'll be coming to the authorities. So what we'll do is we'll rise very briefly so that we can get that and then come back. And the time will not be to your account. My lord has provided my lady with his copy because he, of course, is working electronically.
And he's a gentleman.
He's made it quite clear that if it had been my bundle that had been missing, I'd have had to have gone on found it. Yes, sorry, Mr. Akins.
Yes.
So you were coming to the key dates. First was the 24th of November.
2020, the issue of proceedings.
Yeah.
To say the particulars of claim set out what is on its face,
Yeah.
a straightforward case of trademark. Identical sign, identical goods. Second key date, 28th of January 2021. So we are still before the defence has been filed. And this is when the earlier Stealth mark was assigned from its previous owner, REL Acoustics, to Name Creations Limited.
Yeah.
Now, what do we now know about this transaction? It's recorded in paragraph 32 of the judgment that the defendants confirmed during the hearing below that NCL, so Name Creations Limited, purchaser, was acting on the instructions of the defendants when it acquired that mark. And it was always intended that the defendants would acquire that mark at some stage. So that was what we were told at the hearing below. The development since then is in paragraph 44 of the Respondent's appeal skeleton. The Respondents now concede that the Respondents, and really it's the First Defendant specifically, were the equitable owners of the mark when it was purchased by NCL. Now, we say, contrary to what the Respondents say in their skeleton, that was not conceded before the judge. Otherwise, we wouldn't be running ground 3A, ground of appeal 3A, which is that the judge should have found that the First Defendant had beneficial title from that date. But what matters is that that is conceded now. Now, it's common ground that the earlier Stealth mark had not been used by REL Acoustics, or with its consent, in at least the 5-year period before the date of the assignment. The consequence of that is that if any party had made an application to revoke that mark as at 28th of January or before then, that application would have been successful and the mark would have been taken off the register.
Yeah.
And it is on that date that, on the respondent's case, time starts running for the purposes of Section 46(3) of the Trademarks Act, which is the key statutory provision of relevance to this appeal.
Because they say it's from that date that they were using that trademark.
With the consent of the proprietor.
Yeah.
And my lords, my lady would have by now appreciated that you can defeat an application for revocation of a trademark if you resume or commence genuine use of that mark before the application for revocation is made, but the proviso is that the commenced or resumed use within 3 months of the application for revocation should be disregarded. Now, there are then exceptions to that proviso, which we say are not relevant to this case. The respondents say they are. I've addressed those in paragraphs 9 to 12 of my supplementary skeleton. I don't propose to say anything further about them.
Yeah.
Now, as the judge noted, paragraph 31, Roman numeral 4 of the judgment, it's common ground that this step, so the assignment to NCL, was the first in a series of steps taken by the respondents that was deliberately structured to enable the respondents to use the mark for the 3-month period stipulated in the proviso to section 46(3) without disclosing that this was happening. Once they get past that 3-month period, then we accept for the purposes of this appeal, they're safe from the revocation. So the third date is the 2nd of February 2021. And that is when the defence was filed. So
Yeah.
the assignment to NCL happened a few days before that. Now, no mention was made of the earlier stealth mark in the defence. There was, however, paragraph 4, in which the respondent said, the first defendant is the proprietor of the trademarks and branding used by the second defendant, including the sign stealth. So something was said about registered trademarks and the defendant's ownership and use of registered trademarks. Now, the judge held that this was not false or misleading, this statement, and that is in paragraph 66 of the judgment. We certainly take issue with that. We say, firstly...
You say that's wrong.
We say that's wrong.
Yeah.
At best, it's misleading.
Yeah.
Because they are volunteering information about ownership and use of registered trademarks, and they are leaving out what would be a key piece of information from the appellant's point of view, which is the interest in and use of this earlier mark. And we say they've chosen to say something about, this case is all about the UK, so they've chosen to say something about registered marks not in the UK. It's the only marks that the first defendant had legal title over were outside the UK. And they've omitted key information about trademarks in the UK, about UK trademarks.
There is also the matter of the statement of truth on the defence.
Yes, exactly. Yes. So we certainly take issue with that. It's not an essential, it's not a necessary part of our case on this appeal, but we certainly take issue with that part of the judge's judgment.
No, but part of the background is that I think it's Mr. Byrne, in his statement, takes issue with paragraph 4, but also takes issue with the statement of truth,
Yes.
and describes it as false and misleading,
Yes.
which is obviously a relatively strong allegation, assertion to be made, which is why I looked to Mr. Brownlow's statement to see what the response was, and that's how I know that there was no response.
Yes, that's right.
Yeah.
But even if this paragraph was not considered false or misleading, we know now that it was not the defendant's full case, as known to them at the time, and as intended to be deployed in due course. Because they had already put the wheels in motion, the ultimate goal of which was to deploy this earlier mark in this litigation.
Yeah.
And then looking at the state of affairs at that date, if the respondent's interest in the earlier stealth mark had been pleaded, then the appellant would have applied to revoke it, and that application would have succeeded because it would have been made within the 3 months of the commenced use, and that 3 months is disregarded under section 46.3. Fourth date, 15th of March 2021. This is the date of execution of the trademark license between NCL and the respondents. It's, if I say date of execution, its effective date in the license itself was 28th of January 2021, i.e. the date of assignment to NCL. And that's consistent with that latter date being the date from which, on the respondent's case, the 3 months started to run. Now, there's one particularly odd thing about this license that the appellant noticed when it was provided it, and it wasn't provided as an annex to the draft pleading with the application to amend or with the pleading as served. If I can just take you to that license. So it's in the supplemental bundle, tab 10.
Tab.
10.
Yeah.
So you can see dated 50, on the first page, page 93, dated 15th of March, and you see NCL and the 2 respondents there. And if I can take you directly to clause 13 on page 97 of the bundle, and ask you to read that clause, just that clause.
Yeah.
So we say we now know that that is nonsense, because as NCL was at all times acting on behalf of and for the benefit of the respondents. It was not an arm's length trademark license. Now, my lords, my lady, you will have noticed that the respondents at various points in their appeal skeleton rely on their registration of the assignments of the earlier stealth mark with the UK Intellectual Property Office. But what they omit to mention is that this license between NCL and the respondents was not registered at the UK IPO, despite it being a registrable transaction under section 25 brackets 2 brackets B of the Trademarks Act. So we say if they were being genuinely open and above board, surely they would have registered this transaction, from which it would have been, parties would have been able to find out the respondent's interest in and use of the mark. Now, the respondents have made 2 material concessions about what was possible as at the 15th of March 2021. First, at the hearing before the judge, my learned friend conceded that paragraph 4 of the defence became inaccurate as at that date. So after the licence had been entered into. Second, and again this is a development on appeal, in paragraph 44 of the Respondent's appeal skeleton, they concede that they could have made the amendment to plead reliance on the section 11(1)(b) defence to trademark infringement from this date. And that, as you'll appreciate, is the defence to the main claim for trademark infringement, whereby the respondents rely on use of a earlier registered trademark. They sensibly accept that such use does not need to be by the proprietor and can be with its consent, as under a licence. And so again, pausing there, as at the 15th of March 2021, if that amendment had been made, the section 11(1)(b) amendment, then they would have had to plead the mark to say that they were using the earlier registered mark and the licence, and again the appellant would have applied to revoke the earlier mark, and again that application would have been successful because it would have been brought within the 3 months.
Yeah.
And we could go further than that. The ability to amend was not even limited to the section 11(1)(b) defence at that stage, because it is common ground that it was even possible for the respondents as licensees to bring the infringement counterclaim at this stage. And that's the respondent's skeleton, appeal skeleton, paragraph 15. Then the fifth date is the 15th of June 2021. That's the date.
Mr. Aiken, sorry, can I just forgive me? Just one point. You make the point, and you put it very carefully and accurately, I think, that paragraph 44 of your opponent's skeleton concedes that the section 11 defence could have been pleaded on this date. Do you say that the section 11(1)(b) defence could have been pleaded in the defence in the first place because of the equitable ownership?
We do.
Yeah.
We do, my lord.
I thought so. I just wanted to be
what I'm
absolutely clear.
focusing is on common
No,
ground.
that's fine. I understand. Thank you.
So the fifth date is the 15th of June 2021. That's the date of execution of the assignment from NCL to the first defendant. And this is crucial because it is when the first defendant acquired legal title to the mark. And whilst it was the respondent's position before the judge that the mark only became relevant at all when the first defendant took legal title, as we've seen, the development is that they concede that it was relevant in the sense of supporting the section 11(1)(b) offence before that date. The other material concession in relation to this date is in paragraph 23 of the respondent's appeal skeleton, where they accept that the first defendant could have acquired the mark earlier than this date. And that follows naturally from the concession that the first defendant was the equitable owner of the mark from the date that NCL acquired it. And that's material, of course, because it's now common ground that it was the first defendant's choice to take legal title when it did. And then finally, sixth and finally, 9th of July 2021 is when the amendment was first proffered. And as a result, it was when the appellant first learned of the respondent's interest in the earlier stealth mark, and secondly, the respondent's intention to deploy it in litigation. And crucially, this amendment was proffered after the 3-month period in section 46(3) had expired, and so the appellant had lost the opportunity to deliver the knockout blow to that mark. So, to sum up the key common ground on the dates, the first defendant was the equitable owner from the 28th of January 2021. Paragraph 4 of the defence became inaccurate at the latest on the 15th of March 2021. As I say, this is common ground. The respondents could have made at least the section 11(1)(b) amendment on the 15th of March 2021. and the first defendant could have taken legal title earlier than the 15th of June 2021, and indeed at any point after the 28th of January 2021. So again, as the judge recognised, the defendant's delivery took all these steps in a pre-planned sequence in order to strengthen their hand in deploying this mark. It's paragraph 62 of the judgment. Moving on to ground one. This we say is an error of principle. And we say the error is made in paragraph 65 of the judgment, which is in the core bundle, tab 5, page 47. So yes, paragraph 65. In the first place, this is not, to my mind, a case of a late amendment. And we say this is a failure to apply the principle this is a failure to apply the principle that an amendment is late if it could have been made earlier.
And you make that point, and the judge records it at paragraph 58.
Yes.
But he doesn't actually set it out at paragraph 65.
He doesn't set it out there. He hasn't asked himself the question, we say, could it have been made earlier in that paragraph? And the authority I've cited for that proposition, which isn't controversial, is the judgment of my Lord Justice Coulson at First Instance in CIP Properties at paragraph 19a. And going back to look in detail at paragraph 65, he sets out his conclusion, and then the reasoning comes after it. He first considers the stage of proceedings, and that is expressly not why the appellant said the amendment was late. As I said to my lady, he does not ask himself the question expressly whether it could have been made earlier. However, he does say, and this is 5 lines down, while it might have been possible for the defendants to rely on the licence alone in relation to the section 11(1)(b) defence. That is now common ground. As we have seen, it wasn't before the judge. He goes on to look at the counterclaims and said that they were not available until the first defendant became the proprietor. Again, it's common ground that now that is not correct, in the sense that it could have brought the infringement counterclaims earlier. And we also say that had my learned friend made the concession that he has now made, namely that the first defendant could have taken the legal title earlier, the judge would have held that it was possible to have advanced the counterclaims earlier too.
And that goes to which bit of 65?
So that is the bit after the comma in that sentence that I was just on. So
While it might have been possible.
It was only upon, so the first part of that sentence is dealing with the section 11(1)(b) defence.
Yeah.
And then after the comma, it was only upon the transfer of legal title, the first defendant's name, that the proposed counterclaims became available.
Yeah.
That's what required, in the judge's view, the legal title.
The point you're making is that the judge is saying it was only on legal title, but your point is that what's now conceded but wasn't before the judge is that they could have acquired the legal title at any time after the 28th of January.
That's right.
That's the point you're making.
Yes.
Yeah.
On that part of it, yeah.
On that part, yeah.
But even disregarding that last point,
They could have brought the infringement counterclaim at any time.
yes. But even disregarding that last point, had the judge applied the principle, he should have made a finding that the amendment in relation to the section 11(1)(b) defence was a late one, because it could have been made earlier. Had the judge made that finding, then that would have triggered the obligation on the amending party, according to the principles and the authorities, to explain the delay and give good reason for the delay. Again, that's uncontroversial, but it's back to CIP properties at paragraph 19C. So in my submission, as a matter of the correct principles, the explanation for the delay is not technically part of the assessment of whether an amendment is late. Those are two different questions. Is the amendment late, in the sense that could it have been made earlier, at least in the context of this case, and is there a good reason for the delay? Now, I'll come on to look at the last sentence of paragraph 65, where he does consider whether it was reasonable to delay in the context of ground 3. But in short, I'll make 3 points now. First, before the judge, the respondents did not offer as a justification for the delay the fact that it was reasonable and proportionate for them to avoid making 2 amendments at different dates and wait until the first defendant took legal title and after the section 46(3) window had closed before making one composite amendment. As I say, they said the mark did not become relevant at all until after legal title.
Well, there was no explanation for the delay. That was the point that you made. That they didn't tick the box, or they ticked the box for no statement. And so there was no explanation.
Yes, the explanation at the hearing, given by my friend on his feet.
You can't give an explanation at the hearing because there's no evidence. Because the delay it's not a question of the solicitor pulling counsel's gown and saying, well, the reason for the delay is X. That's a question of the statement. I think we will keep coming back to this. It's one of the very surprising things about this case, given what's said in Mr. Burns' statement. So at any rate, they didn't offer that as a, in inverted commas, explanation. So that's what the last sentence of paragraph 65?
Yes. So that's the first point, the last sentence of paragraph 65.
Yeah.
The second point is in applying what appears to be a reasonableness test, the judge failed to have regard to the consequences for the appellant, and in particular that they lost the revocation opportunity as a result of this reasonable action to put all the amendments in one group. And thirdly, the judge ignored the fact, and may be excused from this because it was not expressly conceded before him, but has been now, that the respondents could have acquired the legal title earlier. So to the extent the respondents suffered prejudice, that came about by their own conduct. So as I say, they naturally fall, those submissions more naturally fall under ground 3, but I deal with them there in brief because it arises in paragraph 65.
Yeah.
So then on to ground 2. And this we characterise as the taking into account of an irrelevant factor. And for that, the error we say is in paragraph 69 of the judgment, so over the page from where we were. And in this paragraph, the judge took into account the fact that the earlier mark was always on the register of trademarks, and it was always possible for the claimant to search for the mark and seek itself to acquire it or apply for it to be revoked. And this, we say, raises the question of policy. Should there be an implied obligation or duty on a party to clear the register in order to protect its position from the point of view of trademark law? I say implied because actually how it has worked in the judge's mind is that the appellant is taken to suffer the consequences of not having done so. So it's considered to be a fault, deemed to be their fault if they don't do that. Now, the respondents have come out admirably clearly on this question of policy in paragraph 26 of their appeal skeleton. They say in terms, it does mean that a prudent party should take the precautionary step of checking the public register and commencing revocation proceedings in relation to any mark that it was concerned might be deployed against it. And we say this cannot be right unless and until an adversary acquires an interest in and commences genuine use of a mark. Then a simple record on a register cannot be of any reasonable concern and cannot give rise to an obligation or duty to clear the register of it. And we rely on 4 matters in support of that submission. The first is that the register does not tell you whether a party is using a mark. And we say that the judge appeared to be under the impression that it did, because he said in his consequentials judgment when refusing permission to appeal, at paragraph 17, Roman numeral 2, that they, i.e. the appellant, could have just checked the register for those using stealth or cognate terms. That's at Core Bundle, tab 6, page 59. And yes, it's the penultimate sentence, paragraph 17, Roman numeral 2.
They could have checked the register for those using stealth or cognate terms.
Exactly, that's it.
So you say that that indicates that he thought that if you check the register, it did tell you who was using the mark.
Yeah, the register will not tell you this. And the distinction between what is on the trademark register and actual use of a trademark pervades the law and practice of trademarks, as my Lord Justice Birss will be aware. And it does it in a number of ways. If a mark is not put to genuine use by the proprietor with its consent, it will be liable to be revoked, and so taken off the register. Second, a party cannot assert an unused mark against another registration in validity proceedings, and that's sections 47 brackets 2a and 2b, which concerns invalidity proceedings. And further, evidence of the state of the trademark register is valueless in trademark disputes. So, for example, simply showing the court that there are lots of marks on the register containing a particular word does not support a submission that the word is incapable of distinguishing one person's goods from another. Your evidence has to show what the actual use is being made of these words in the market, which the register will not tell you. So that's the first matter in support of my solution. The second matter is the whole point of section 46.3 is that if there is an earlier mark on the register which hasn't been used for more than 5 years, but the genuine use is commenced or resumed, then someone who might be affected by that earlier registration has the 3-month window in which to take action to revoke that mark. If they take that opportunity, then the mark will be revoked and it cannot be asserted against them. So the statutory scheme affords a party with full information this 3-month opportunity to do something about something that is on the register but hasn't yet been used. or hasn't been used for a significant period of time. So again, we see that shows this fundamental distinction between what's on the register and use by the proprietor or with its consent. And that fundamental distinction is built into the system. The third matter is the Walton case that I cited in my supplementary skeleton.
Do you want us to go to that?
Yes, please. It's Authorities Bundle, tab 6. And the passage that I've marked up starts on page 129 of the bundle. So this is a judgment of Mr. Justice Arnold as he then was in a trademark case, and it is the context of the passage that we rely on is that there was a claim for infringement, and the defendant's, one of the defendant's defences to infringement is a defence of honest concurrent use. It's also pleaded in this case, but it's not relevant to this appeal. And it was said against the defendant that they should have checked the register to see, to locate the mark that is said to be infringed. And so you can see the point that is made is in paragraph. So yes. So you see, it starts assessment on page 130 in 209.
Yeah.
And there are two reasons why the defendant cannot satisfy the onus of establishing honest concurrent use. And we're concerned with the second here. The defendant's use of the sign Giordano had not been honest. And then the judge picks up the second point at paragraph 213 on page 132 of the bundle. And you see in that paragraph, in the second sentence, the claimant argued that even if the defendant had not known of the mark until relatively recently, the defendant ought to have carried out a search of the UK trademark register before marketing its goods here. And then the judge rejects that argument in paragraph 214 for three reasons, and it's the second that I rely on the third line of that paragraph. Secondly, counsel for the claimants did not say what the defendant was supposed to have done if it had carried out a search and found the mark. The logic of the argument appears to be that it should have applied for revocation prior to marketing its goods, but I do not see why a defendant should be under a duty to make such an application prior to marketing.
No.
So I accept that the context is different. It's in the context of defence to infringement. However, I rely on it because it is a judicial statement to the effect that a party potentially adversely affected by a trademark on the register is not under a duty to take a positive action to remove it from the register, such that if it doesn't take that action, it would have to suffer the consequences. By contrast, the respondents have not cited any authority in support of their position that it's incumbent on a party to search the register and commence revocation proceedings in relation to any mark that is concerned might be deployed against it. Then the last point in support of our argument on the policy point is that the defendants obviously appreciated this difference and that it wasn't incumbent on the claimant to do this. Otherwise, they would not have taken the steps they did and concocted this deliberate scheme to conceal the purchase and use of the mark. They did that because they know, as a matter of practical reality, that no one takes any action to clear the register until an earlier mark becomes relevant. And it becomes relevant when there is commenced or resumed use by a proprietor with its consent, or there's a transfer to an adversary who may be using it. So for all those reasons, we say the judge should not have taken into account the fact that the earlier mark was on the register all the while. And that leaves ground 3. And we characterise this as the failure of the judge to take into account a relevant factor, namely that it was entirely the respondent's choice to sequence things in the way that they did, and in particular, to separate the legal and beneficial title of the earlier mark, which is what the defendants rely on as the reason for the delay in making the amendment. So the first thing to note is that, as we've already seen, the respondents have now conceded ground 3A, which is that the judge should have held that the first defendant was the beneficial owner of the earlier mark from the 28th of January 2021. And that's significant because your lordship and your ladyship will have seen from the judgment that the judge accepted the respondent's submission that they were only required to make the amendment when they took legal title of the mark, which was on the 15th of June 2021. And that is, going back to the judgment, the end of paragraph 65. So again, that's the core bundle, tab 5, page 47. I consider it was reasonable for the defendants to make one application to amend once the legal title had been acquired, rather than applying piecemeal as events developed, and that they did not abuse or violate the process of the court by waiting until then. Now, here the respondents might argue that the judge has taken the second step of the analysis, namely, if an amendment is late, is there good reason for the delay? Again, as my Lord Justice Coulson has noted, no evidence was served that contained any reason, let alone a good reason. However, the respondents in their appeal skeleton have now latched on firmly to this one application or one set of amendments reason as their good reason. In paragraph 44 of their appeal skeleton, they say what matters is that it was proportionate to introduce the amendments comprehensively, including the counterclaims, and to do that, it was proportionate and reasonable to wait until the legal title was acquired. And they also give the same reason for not correcting paragraph 4 of the defence, which they concede was inaccurate from the 15th of March 2021 until the first defendant took legal title as well. That's paragraph 22 of the appeal skeleton. But this all relies on the separation between the legal and beneficial title. If there was no such separation, then even on the respondent's own case, there would have been no reason to delay until July 2021 to make the amendment. And crucially, this was entirely a situation of the respondent's own voluntary creation. It was their choice to separate the beneficial and legal title. And we say the judge's error was in not asking himself whether that was a good reason for the delay. Had he done so, he would have held that it was not, because it could have easily been avoided. There was no independent reason to separate legal and beneficial title. And it's possible that the reason why the judge did not ask himself that question and answer it in the way we say he should have done was that he didn't have the benefit of the respondent's concession. That was the first defendant was the equitable owner from the 28th of January 2021, and so could have taken the legal title at any time. But even if, against me, one doesn't accept that position, and that there was some justification for the separation of legal and beneficial title, then the supposed justification for the delay is one of reasonableness and proportionality. And there we say the judge's decision was plainly wrong, and in particular to decide that this was a reasonable way to proceed, to bring all the amendments in one go. It's common ground that the Section 11(1)B defence could have been brought earlier, on the 15th of March, and the amendment to plead that defence would have amounted to a few paragraphs of marked up text in the defence. That could have been sent, that markup could have been sent to the appellant in draft on the 16th of March 2021 on the respondent's own case. This is hardly an onerous task at all and would not have added materially to the costs. And if they had to wait to make the other amendments until legal title was taken, they could have added the remaining paragraphs in June 2021 in a re-amended defence and counterclaim. Again, hardly onerous. And that needs to be weighed in the balance as against looking at matters from the perspective of the appellant. If the amendment to plead Section 11(1)B had been made in a timely manner, the appellant would have been alerted to the interest in the earlier stealth mark and would have made the revocation application in a 3-month window. So we say it cannot be proportionate or reasonable to avoid a straightforward two-stage process when the consequence is to deprive the appellant of a material advantage and thereby cause prejudice to the opposing party. So, as I say, in that respect, we do say that the judge's decision was plainly wrong. And again, the judge failed to have regard to the prejudice caused to the appellant when considering whether it was reasonable to wait and do it at the same time. On the other side of the coin, the respondents say that the appellant has ignored the consequences and prejudice to the respondents of refusing the amendment. And that was noted by the judge in paragraph 70 of the judgment.
70.
70, page 48 of the court memorandum. But we say, again, there is an error in this paragraph because the judge did not apply the last principle in CIP properties. I can take my lord to my lady to that. That's tab 2 of the authority to my lord. So this is, you'll be aware, a judgment of my lord Justice Coulson, Mr. Justice Coulson, as you then were, first instance, and the principles, the right approach to amendments is set out in paragraph 19, starting on page 33. You can see in subparagraph A, second line, an amendment is late if it could have been advanced earlier. It's uncontroversial. None of this is controversial.
Yeah.
but then for this purpose I rely on subparagraph F of the page. Prejudice to the amending party if the amendments are not allowed will obviously include its inability to advance its amended case, but that is just one factor to be considered, and crucially, moreover, if that prejudice has come about by the amending party's own conduct, then it is a much less important element of the balancing exercise. And indeed, in this case, I haven't marked this up, but in paragraph 64, on page 43, you can see that my lord refused permission for one of the amendments precisely because the delay in making the allegations was wholly the responsibility of the amending party. And therefore, that was not a factor on which the claimant could properly rely. So we say the judge failed to apply this principle in paragraph 70 of the judgment. Had he done so, he would have refused the amendment because the entire reason for the timing of the amendment, namely that the respondents did not take the legal title until the 15th of June, was a situation of the respondent's own making. We say, following CIP properties, that was not the prejudice to the respondents in not being able to rely on their case was not a factor in which they could rely.
Yep.
So, my lords, my lady, for all those reasons we say the appeal should be allowed and the amendment refused. The consequences of dismissing the appeal and letting the amendment stand would be that the court would be approving the use of the amendment procedure as a weapon in litigation. It would endorse the approach of withholding parts of one's case and adding them at the optimum stage so as to do most damage to the opposing party and secure the most advantage for the amending party. We say that's contrary to the overriding objective, it is contrary to the modern approach to litigation, and it is contrary to the principles of the authorities, and it should not be allowed. So unless you have any further questions, those are the appellant's submissions.
No, thank you very much, Mr. Akins. Yes, Mr. Randall.
My lords, my lady, my learned friend has made a great deal about new concessions that I'm supposed to have made on behalf of my client, either in the course of my written argument or in addressing the points that he makes on appeal. We say we've done no such thing. I said in my skeleton argument that this was the claimant's third bite at the cherry, but I was wrong to do so. It is in fact, we say, the fourth. And the matters to which my learned friend has drawn your attention today in all argument are matters that have arisen for focus in my skeleton argument in responding to the appeal, because it is my learned friend whose position has shifted. And to make that submission good, may I ask you to take up the transcript, which you will find in the supplementary bundle behind tab 13.
Yep.
To turn within it to page 116 in the bottom right-hand corner, which should be the first day of the proceedings, pages 44 through to 47. The context of this discussion, which is the submissions of my learned friend to the judge, is the discussion of that paragraph 4 to which my learned friend has referred. And if one looks at the bottom of page 47, you see that the learned judge is addressing one of the points that my learned friend now says I've made a concession about, namely the issue of the equitable ownership of the mark, and therefore the significance of the date of the 28th of January 2021. If you then turn over the page to page 48, the judge having asked, this is an important part of the case, is it not? A paraphrase there. Mr. Akins goes on to say that case on beneficial ownership is not something that is relied on in the summary judgment application. It may be, if the amendment is allowed to proceed, there's a point that will be taken. But on the face at the moment, Name Creations was the owner. Now, my lords, my lady, as you'll see and has seen in my skeleton argument, we accept that the 28th of January date had a potential relevance for the reason that my Lord Justice Birss already raised, namely that even absent the question of equitable ownership, by virtue of the fact that we say we were using the mark, the defence was potentially available. And we say that you see here that the judge is well aware of that question, and indeed that's why, as my lady indicated, he reflects it in what is said in the judgment in paragraph 58. My lady then went on to say, but he doesn't seem to follow the raising of that earlier date, that issue of the early amendment, through into his reasoning in paragraph 65. We say that's not right, my lady. In fact, he is expressed, even in paragraph 65, in acknowledging that there was a potential relevance earlier, but taking that as part of an overall consideration of the question of lateness. But more than that, my lady, we say that when you turn further to the consequentials judgment, you see he returns to precisely that point when he dismisses this particular permission for appeal. And that is to be found in the core bundle, my lady, behind tab 6, in what is said in paragraph 17I. And in the middle of that paragraph, you see he explains lateness is a relative concept which has to be assessed in all the circumstances, including the stage of the proceedings and the work that potentially be thrown away, as well as whether the application could have been brought earlier. And my lords, my lady, you will see from the transcript that this issue of whether or not there was relevance to section 11B, either by virtue of equitable ownership or earlier licence, was a subject of considerable discussion, both with myself and my learned friend.
Mr. Bradworth, you referred me to para 50, you referred us to para 58 of the judgment, where the judge is recording a submission from your opponents.
Yes.
I don't remember, and please show me, where did the judge decide whether or not you could have brought the claim on the 28th of January?
Whether or not
I don't remember seeing the judge deciding.
I'm sorry, my lord, if I've given the impression...
58 was a place where the submission was made.
Paragraph 58 records the point that there was a relevance to this mark, potentially from an earlier date, namely from the 28th of January 2021.
Yes. But did the judge
Paragraph
decide
65 is then the discussion of the issue of lateness. And in its course, he explains, middle of the paragraph here, while it might have been possible for the defendants to rely on the licence alone in relation to the section 11(1)B defence, and then he goes on to explain it was only upon the transfer of the legal title to Mark 250 into the first defendant's name that the proposed counterclaims became available. That is the point that I'm referring to, my lord. Whether that amounts to what you would describe as a decision that we could have made the amendment earlier, perhaps it would go too far to say that. But to say that he was unaware that there was a potential relevance to an earlier date is unsustainable, we say, either on the basis of those two paragraphs or on the basis of 17I.
So the paragraph 65, the sentence that starts, it might have been possible for the defendants to rely on the licence alone in relation to the section 11(1)B defence, does that mean as at the date of the defence on the 2nd of February?
Yes, my lord, and I think the difficulty there is that my lord, Mr. Justice Miles, was using licence in a way that perhaps I, as a trademark lawyer, railed against. You see that in the transcript. Because he understood it to also include what I would consider simply to be use by consent, as opposed to the kind of licence, such as the one on the 15th of March, that is written and needs to be dealt with by way of a deed. And he encompassed both when he referenced licence, which is why, when one looks back at paragraph 58, he references the earlier date of the 28th of January, at which point there was no formal licence.
Okay. So you say 65 when it refers to licence isn't thinking about the 11th of March when the licence was entered into, but the 28th of January.
I think it's
consent
thinking of.
started?
I think it's thinking of both, my lord,
Okay.
because both have potential relevance. Now, my lord, one must recall that one of the counterclaims that we sought to bring was a counterclaim for invalidity of the mark, and that was refused by Mr. Justice Miles. But it was a point at the time that informed the amendment. And whatever the position in relation to counterclaims on infringement, and whether they could have been brought earlier, we say, for the reasons I've given in my skeleton argument, expanded upon in the footnote, a counterclaim for invalidity is only safely made once you are the proprietor. It's only safely made because, as I indicated in my footnote, there is some ambiguity there. But even in relation to counterclaims for infringement, my lords, my lady, we do say, although it is possible to bring it without being the legal proprietor, as a practical matter, it is appropriate to bring it once you've obtained the legal title. My lords, my lady, I've dived straight into that, taking myself slightly out of my course, because it seemed to me a point on which, my lords, my lady, you wished to hear me immediately. And it is a point that we say reflects the fact that nothing that you've been told today is something of which Mr. Justice Miles was ignorant in coming to his decisions. In that consequentials judgment, and I don't know if you still have it open before you at tab 6, paragraph 17, whilst rejecting the application for permission to appeal, Mr. Justice Miles makes exactly that point, namely that he's addressed each of the issues now advanced in his main judgment. These are not new points. Now you see that the learned judge also reinforces his position on permission by reference to the two preceding paragraphs. The first about the approach to review of exercise of discretion. My lords, my lady, we're all familiar with that authority, and it doesn't appear to be a question of dispute. But the second is that the claimant's challenges address only part of the reasoning of the court in the exercise of its discretion. In particular, the question of the prejudice to the defendants if the amendments are refused. We see on that second point there has been largely silence from the claimant, both in writing and in the oral submissions today. And that's a surprising silence, given that it is a point expressly and repeatedly made by the judge when addressing the alleged grounds of appeal. Surprising also, given that it is a point expressly made at pages 15 and 16 of my skeleton. And we say an important point, my lords, my lady, for you in considering these issues. Now, we submit that Mr. Justice Miles' judgments reveal no error of law, no matter taken into account that should not have been, no omission of a matter that should have been considered. The only errors of law, we say, are those to be found in the appellant's submissions, in the construction of section 11 of the Trademarks Act, in the explanation given of the purpose of section 46.3, and in the partial and we say tendentious rendition of the principles on amendment. And the only omissions to be found are in my learned friend's argument when he fails to consider the whole picture and to give weight to matters such as the effect on my client if these amendments are refused. My lords, my lady, we resist the idea that this is an unusual case. Although in saying that, I must pick up on my Lord Justice Coulson's reference to the evidence. And I'll do so, if I may, in the context of ground 1, where I think it arises. But whilst resisting the idea that it's unusual, we do accept that it is unprecedented. And I'll explain the sense in which it is when I come to considering that policy question, and what we say is a thin end of the wedge fallacy advanced by my learned friend. But it is not unprecedented in the nature of the amendment. So unprecedented, yes, and also we say unfortunate. The circumstances of this case, we say, are unfortunate for the reasons I've given in my skeleton argument beginning at paragraph 3. It is my client who is in an unfortunate position, having been the first to put the sign stealth in relation to audio headsets before consumers, having had a protectable goodwill long before the claimant, and having activity vastly greater than the claimant, being in a position where we say consumers understand the sign in issue to mean at least my client's goods. Now, when the claimant was the first to apply for a trademark, not for stealth but for a stylized version of the words stealth VR, and the issue was tested in the IPO, the hearing officer held that, and this was unknown and unknowable by the defendants, there had been use by the claimant in a marketing pitch to a trade consumer. Now, that was enough to render our prior goodwill useless for invalidating the claimant's trademark. And we pause there to observe that there is a bitter irony here, that the claimant now complains about the effect of something it didn't know about the defendant's actions, and the origin of this case lies in the effect of something that the defendants didn't know about the claimants. And I say it is a bitter irony because there is a difference between the parties in this regard. The defendants could have done nothing about that status, but the claimant had always in its power to check the public register at any point and to take action. The consequence of these amendments is that we give effect to what we say is the reality for consumers on the ground. We obtain the protection of that earlier registration. That is the purpose of these amendments. They end the claimant's attempt to obtain a windfall benefit from the vagaries of trademark and passing off law, as they end the potential claim to injunctive relief. It is that this claimant seeks to prevent. The consequence of these amendments, we say, is to allow the statutory scheme to take effect, for the defendants to be allowed to pay the benefit of an explicit statutory defence. And in doing so, we say to achieve not only justice for the defendants, but also to avoid a state of confusion for consumers. Now, having lawfully acquired this trademark, we say we were entitled to advance an amendment to introduce it, and that it was appropriate, reasonable and proportionate in the context of the case as it stood, to amend to introduce not only the defence issues, but also the counterclaim issues in one fell swoop. My learned friend says to you, as he said to Mr. Justice Miles, that the amendment timing remained in our hands. That's because the legal title could have been acquired earlier. We needn't have used an agent, nor waited until the mark was secured against revocation for non-use within the proviso period. Now, the consequence of our doing so, proceeding in the way that my learned friend suggests we should have done, or rather in the way that we say that we have done, is that my learned friend has lost the chance to rely on the proviso period. And we say that is a point in our favour on this appeal, not against us. We say we were entitled to proceed in a way that secured the registration and the benefit of the statutory defence that it provided.
Under the Act?
Under the Act.
Yes. We're not, I don't think that's in dispute.
No, indeed.
What we're concerned with is the potential abuse of the court's process.
Indeed, man.
So I don't think there's any dispute that you were entitled to act as you did under the Act.
Indeed, but that we say is a very relevant consideration to the question of whether we acted in an abusive way. What my learned friend is suggesting is that we should have introduced a mark by acquiring it, legal title and all, right at the outset, at a stage where, as my learned friend says, there would have been a slam dunk basis for invalidating, for revoking it. Well, such an amendment would then have been purposeless. We say, therefore, that we were quite right to proceed in a way that ensured that this mark had the relevance that we say it would have to the action, in two respects. One, because it was only, we say, as a result of obtaining the legal title that we were in a position to bring the counterclaims that we wished to bring. But two, because in order to benefit from the defence, the trademark must be valid, and therefore we were entitled to avoid the difficulty of the slam-dunk revocation action that my learned friend says he would otherwise have had, and that there is nothing abusive about doing so. in circumstances such as this one. There is no general principle that is being addressed here. This is a question on the specific facts of this case. And the second reason I say why it is important that we have acted in an entirely lawful way is because none of the acts that we took under the Trademark Acts and rules involved us avoiding an obligation to let my learned friend know that we had a potential interest, or indeed any interest, in the mark before the moment that we did so. We say
avoiding letting if the reason you didn't acquire the legal title on the 28th of January is because that would have meant the register showed you had the mark, and that would have tipped off your opponents.
That's right.
I mean, I infer.
No, my lord, that's right.
I'm asking you the question.
No, as a
Doesn't
matter of law,
doesn't that contradict the submission you just made?
No.
Without any evidence.
It is exactly to the point of the submission I've just made.
Right.
My lord, we were entitled to secure that registration against an easy win within the 3-month period of the proviso, in order to ensure that it remained relevant when it was deployed in the action. To do otherwise would have been to have taken a pointless step, to have asserted a mark that would have been immediately revoked. My learned friend's argument that we should have, for example, have obtained the legal title at the outset is therefore a submission that we should have acted in a pointless manner. My learned friend needs to show you, in a way that he did not manage to show Mr. Justice Miles, that we were compelled by either a legal or an equitable obligation to act in such a pointless manner.
No, that puts it the wrong way round.
Sorry, my lord, I didn't hear you.
It puts it the wrong way round. You were asking the judge for an indulgence.
Yes,
They didn't have to show anything. You were asking the judge for the indulgence of being allowed to amend your defence.
that's quite right, my lord.
So it's not. It wasn't for the claimant, now appellant, to do anything. It was for you to show that that was an appropriate application to make.
Absolutely
The
right.
burden was on you.
Absolutely right. We don't depart from that position of law. We say that's precisely what we did do in front of Mr. Justice Miles. Mr. Justice Miles accepted, and this was not a point raised in the appeal, that we were entitled to wait to amend in a comprehensive manner to include the attempted counterclaim.
Well, we'll come to that when we look at, as you say, Underground 1.
Yeah. He also accepted, and this is in paragraph 108 of his judgment, that we thought that we were entitled to proceed in that way. The reason that I address you in the way that I did, my lord,
108.
108 of the main judgment, my lord. So here he's addressing one of the points effectively under ground 4 now abandoned.
Yeah.
Namely, that because the counterclaims were bound to fail, it wasn't right to wait for the counterclaims before amending. And in 108, he's looking at the consequences of that hypothetical.
Yeah.
And you see, he says midway through, I'm satisfied that the defendants proposed the amendments in good faith. That is a finding that's not appealed, my lord. And it's consistent with his position on paragraph 66, where he accepts that we understood that we were right to wait in the context of the proceedings as they stood and where they were at that time, to produce them, to bring them before the court in a comprehensive manner, because we wish to introduce those counterclaims as well as rely upon the defence.
Well, that's a problem because there was no evidence in relation to that, so he wasn't entitled to come to that conclusion.
No evidence.
There was no evidence that you decided to wait.
Well, my lord, what there was evidence of
There was no evidence that you decided to wait because there was no evidence from your instructing solicitor about the conduct and how it was that the amendments were being made when they were.
Well, my lord, there was evidence of the chronology by which we acquired the mark, which I accept is not the same.
Oh yes, certainly there was. I mean, a lot of the chronology is not
And
disputed.
We argue, and it was accepted by Mr. Justice Miles, that they were not late amendments, that they were amendments that were justified because the point had been reached at which the marks became relevant in the ways that they were.
We understand that. Yes, we quite understand that there's a dispute about whether they were late amendments. But if they were, there was no explanation as to why they were late.
because we
I mean,
say,
when you
Yes,
look
that's
come
quite
to
right,
these
Mark.
when you come to these papers, that's the thing that sticks out like quite a sore thumb.
Well,
It looks really odd that you know quite important matters are raised in the statement opposing the amendments, which are not addressed.
well, my lord, there are two matters that I think arise. The first is your point about the misleading paragraph 4. The second is the question of the timing of the amendments.
A false statement of truth actually trumps all of that.
Well, indeed, my lord, that's the point
I
I'm
mean,
referring to as the first one.
I don't link that just to paragraph 4.
Well, my lord, it was in relation to paragraph 4 that the falseness was said to arise.
Well, that was part of it. I mean, the short point is this could have been pleaded in the defence. I mean, that's now agreed. And indeed, the judge, you say that middle paragraph of paragraph 65 says that. So if it could have been pleaded but wasn't, then on the test, it's a late amendment.
Well, my lord, we say that the test is one of general consideration, in which the factor, could these matters have been raised at an earlier stage, is but one part of the analysis. And that is what the approach taken by Mr. Justice Miles was, and that he was quite right to deal with it in that way. And that was the view that we took, that it was a matter of argument, and that the overriding factors were those that related to the status of the case at the time, and the context that I've set out in my skeleton argument when I deal with context from paragraph 14 onwards. My lord, let me turn to what we say about Brown. And we are making 2 points. The first being the one I've just set out, namely, that we say on the authorities, and appreciate one of them as a judgment of your lordship, lateness is to be understood as a relative concept and assessed by reference to a range of factors, of which only one of them is the question of whether or not it could have been made in some sense earlier. There is a second point, to which I've also already referred, namely, even if it was an error, and that formally, under the authorities, it should have been treated as being late, it wasn't material to the overall exercise of his discretion, and that is precisely the point that Mr. Justice Miles himself makes in paragraph 17 sub I of the consequentials judgment. Indeed, the first point we make is that Mr. Justice Miles plainly had the very paragraphs, the very authorities to which my learned friend now refers in mind. And you can see that in what he says of paragraphs 38 and 39 of the judgment. We say that my learned friend's submission errs in that it seeks to elevate a single factor relevant to the overall assessment of the relative lateness of the amendment to a simple box-ticking exercise. And we say this is not that kind of exercise, not an algorithmic process, but an evaluative one. We draw your lordship's particular attention to what is said by Lord Justice Briggs in the SIP judgment, to which my lord refers. That's at tab 2 of the Joint Authorities Fund. My lords will be familiar with the authorities and with the summary that is given at paragraph 19 onwards on page 33. But prior to that, my lord has reviewed the authorities in order to come to that summary, and one of the authorities is that given in Hague Plant at Hague, and there is a quote from Lord Justice Briggs. One sees that beginning at the bottom of paragraph 32, going across to paragraph 33.
Shall we just read that?
Please, ma'am.
Thank you very much. Yeah.
I draw the bench's attention to it partly, of course, because my lord then specifically references it in what's said at 19A. It is from that judgment that 19A takes its first sentence. And what we say is that rightly there, Lord Justice Briggs is setting out that this is an evaluative question that the judge must embark upon, having regard to all of the circumstances of the case and the context of it as it stood at the time. For example, any impact on the trial date is a relevant factor, even if the trial is many, many months away. Similarly, an amendment proposed months beforehand, which has a substantial effect, may be late, whereas an amendment concise, tightly drafted, and of small effect even a few weeks beforehand may not be late. Now, we say what that indicates, rightly, is that it is a question for the judge confronted by the issue of amendment to look at all of the factors and to come to a conclusion as to whether or not the issue can be described, the amendment can be described as late. And we say that is precisely what Mr. Justice Miles did by reference to precisely the sorts of factors we say he was entitled to look at, namely the stage of the case, the fact there wasn't even the close of pleadings, no CMC, no trial date, but also that he did take into account precisely the point my learned friend now raises as an error, namely that aspects of the relevance of this 250 mark could have been raised earlier, including, as my lords indicate to me, on the 2nd of February. My lord, I note that there is a commentary in this particular version of the judgment. Commentaries have, in the United Kingdom, very little weight. But the final paragraph on page 27 does my lord, my lady have it? It's hoped, however.
Maybe that my lord knows the answer, but I don't know. Was this a commentary written by the judge? Or?
No, my lord. I don't believe it was. I certainly,
Judge.
I certainly don't. It's an editorial comment. You see that at page 26. I don't put it forward as having any status or weight, in the sense that it's can be in Germany.
I think that we could probably all agree that amendment applications should not become the focus of any narrow inquiries. And I'd say in this case, it seems to me it's the opposite. In this case, I appreciate there was also a summary judgment application, but it was a 2-day case and a judgment that runs through over 100 paragraphs. So I think narrow inquiries were avoided in this case.
Well, indeed, my lord, but what I would say is that that comment reinforces the point I am making about how one is to understand the evaluation of lateness. Namely, as I say, that it is not, as my learned friend says, a simple box-ticking question. If you have this particular factor, then it is to be defined as late, but rather an evaluative one. And that when my lord, Mr. Justice Miles, engages in that process, he correctly takes into account all manner of issues, including the one that my learned friend now says he didn't. And in that regard, we say that there is relevant context here that my learned friend has not raised with you, and it's the ones that we set out in my skeleton argument at paragraphs 14 onwards. The second of which is the one at paragraph 16, where the proceedings stood at that point. Because this was a case where the pleadings had not closed. There had been no CMC, there was no trial date. It stood waiting for the determination of the claimant's application for summary judgment. And indeed, my lords, my lady, as a result of this appeal, there is still no CMC in this action. There is still, in 2022, in respect of a case that was issued in November 2020, as a result of the claimant's applications and appeals, no trial date. Now, in July 2021, when the amendment was advanced, the claimant had not even served a reply. There has therefore been no delay, no wasted costs, we say, arising from this amendment by virtue of its timing. And there'll be no effect on the trial date. Those are matters reasonably taken into account, expressly so by the judge. And justifying, we say, a conclusion that the amendments were not to be categorised as late, notwithstanding the point my learned friend now makes.
What's the purpose of deciding whether it's late?
My lord, it is a feature of the overall assessment of whether or not it would be appropriate to permit the amendments.
Right. That's a very elegant non-answer to my question, Mr. Brown. I mean, if you don't know, that's fine, but
No.
do you have a submission about what the purpose of deciding whether an amendment's late or not is?
Well, my lord, it feeds into the question of whether or not it will have an impact on the trial in one respect. That's why some of those are described as very late. And also, it has an impact on whether or not, if there is prejudice being suffered by the party who seeks to amend, that is something to which it must consider itself responsible.
I mean, it seems to me, at least, that it's one reason, no doubt not the only one, is because if an amendment is late, then one might want to require a good reason by the party making the amendment for excusing the lateness.
Indeed, my lord.
Yeah.
And that's why we point out, my lord, that it was, in our view, a question of argument, and that the judge below accepted the argument that we made, that it was not a late amendment in the context of the case. The state of the proceedings, my lords, my ladies, is not the only relevant matter of context. The other is the point that I address in paragraph 15. And that's the point about the broader relevance of the counterclaims. As I say, I've drawn your lordship's, my lady's, attention to the paragraphs in the judgment. It was the view of Mr. Justice Miles, based on our argument, based on the chronology and the state of the proceedings, based on the implications of the need to obtain legal proprietorship before bringing a counterclaim for invalidity, that it was appropriate for us, reasonable and proportionate, to bring these amendments in a comprehensive manner. We don't shy away from the fact, indeed I've advanced it right at the outset, that a further consequence of
So
proceedings...
I missed that. You don't shy away.
Don't shy away from the fact, and indeed I've advanced it right at the outset of my submissions to you, that a further consequence was that it secured this mark for the purposes of the very defence that it was supposed to bring about.
Yeah. Well, you've been entirely upfront about that.
You cannot expect us to make a purposeless amendment, and yet that is what my learned friend says we ought to have done. The final point, my lord, is simply a repetition of what I've said before, which is that this is but one aspect of the overall discretionary exercise carried out by Mr. Justice Miles, and in respect of which my learned friend has not explained why it has such significance, we say, as to outweigh what we argue would be an enormous prejudice to myself, to my client. But it does therefore bring me to ground two, because it's in that context that we are dealing with prejudice. Because here the error is said to be taking into account that the 250 mark was on the register, and the failure of the judge being to recognise that there were no reasonable grounds for being interested in that 250 mark, absent ownership by the defendants. Now we say that the presence of the mark on the register is plainly relevant, and we set out why in my skeleton at paragraphs 23 to 36. It's important to appreciate that the potential relevance of the 250 mark is inherent to it, and I explain why that is at paragraph 33 of my skeleton argument. Its inherent relevance arises from it being an identical sign, stealth, we say, for identical goods. It was, we say, therefore, of potential relevance, quite apart from who owned it. Now, in that paragraph of my skeleton, 33, I go on the basis, the assumption, that the claimant's lawyers did indeed check the register. We understand from their supplemental skeleton, again, by implication, they don't wish to go into privilege matters any more than I do, that in fact they had not done so. And indeed, my lords, my lady, you'll see in my previous paragraph, I contemplated that possibility. Paragraph 32 begins on that basis. You see that just in the bit. Failure to act is the result of one of two possibilities. And I confess, my lady, my lords, we're surprised that there was not even an elementary review of the register for potential clashing rights. But if it is the case that there was not, then that only reinforces the point that we are making in this section. 250 mark was not being hidden by the defendants. The sign and its specification were in plain sight. That's how we knew of it and of its relevance. It could have been revoked at any point for the small price of a letter and a form at the IPO, but it was not. It was not even a check of the register, it was a tactical decision by the claimant. And they are entirely responsible, we submit, for the consequences of that decision. It was not an error to take that into account where it is said that the prejudice they have suffered is that they have lost the chance to revoke the 250 mark for non-use in the 3-month proviso period. We say, in fact, it's directly on that point, because it reveals that they did not lose the chance to revoke the 250 mark for non-use, but rather the chance to be told that they needed to do so by the defendants. And that, we say, is a very different thing. And I think, my lord, in a sense, it ties back to the point you put to me earlier. We were coming seeking an indulgence. And why I submitted to you that it was an important consideration to ask whether we were under an obligation to let them know. Because it does feed into this question of the nature of the prejudice they say they've suffered. It is not the lost chance to revoke in that 3-month period, but rather the lost chance to be told they needed to do so. And that, we say, thrusts into the foreground their own role in that state of affairs. And that, we say, is again recognised, because again, this is not a new issue, by the judge, explicitly so, paragraph 17, sub 2 of the consequentials judgment. And for your notes, that's page 59 of tab 6, page 59. Now, in this context, the claimant makes a number of suggestions. And the first is an allegation of deliberate concealment, and I do rail against that terminology. They say we appreciated there was a significance to our ownership and use of the mark and therefore kept it quiet. Well, we say we were under no obligation to announce our interest. That is very different from concealment. The Act, we say, has given specific consideration to what must be notified in section 25 and to the consequences of not doing so. There is no part of the Act or of the trademark rules that requires a party to notify another that it's using a trademark or intends to acquire a trademark or take a license under it. I think, my Lord Justice Coulson indicated that this was a point on which I didn't need to spend much time, because
It's certainly not my understanding that, certainly speaking for myself, I don't think the appeal stands or falls on this question of breach or potential breach of the Trademark Act.
Yes. The reason I've spent some time on it is because obviously my learned friend comes before you to say that we've acted improperly or iniquitously, I should perhaps more accurately say. And we say it is relevant in that circumstance to resist the description of our actions as deliberate concealment.
So do you say that's we've got evidence from which we can conclude that you didn't engage in deliberate concealment from the perspective of the civil justice process?
Yes, I do say that, because you know that we registered every step of the acquisition of the mark, and you know that we pleaded from the moment that we put the pleading before them, every step of the process by which we pleaded it.
We registered. Yeah. We registering something doesn't usually mean using a shell company with a name which doesn't indicate yourself.
But I did register it and register the fact that I'd acquired it. There was a prior step to that, and I've also been open about that. It's in the pleading. And that was also registered.
Right. I mean, I understand that we now know what happened, but I'm struggling to see how it isn't a perfectly legitimate inference to say that you deliberately concealed your interest and involvement in this prior to the date on which you registered, or your client registered its own name.
Well, my lord, thereby means by deliberate concealment, we didn't tell them. And if that's what my
Well,
lord
first of
means,
all, it's a pretty fair inference that everything that was done deliberately.
absolutely, my lord.
And what I'm putting to you, Mr. Brandreth, is it's also a perfectly legitimate inference that what was done deliberately was concealing your client's involvement in the exercise. You say you were entitled to do it.
Yes.
That's a different question from whether you deliberately concealed your interest.
I see. My lord says to me, the point of using a cutout, to put it that way, the agent, was to delay the moment at which our acquisition became a matter of registration. That's the query.
Well, if I may say so, Mr. Brandreth, you started it. You're the one who
No,
submitted to me
I'm
that
sorry,
it wasn't right to characterise
My
your
lord,
client's
I'm
behaviour
not
as
trying to
deliberate
debate
concealment,
it.
and I'm trying to understand how that submission
I'm
fits
sorry,
with the facts.
I'm not trying to debate it. I'm just trying to make sure I've accurately understood the point that your lordship is making.
Right.
Because I agree. And as I say, quite up front and did at the beginning, our whole purpose is to ensure that this is a meaningful amendment of a mark that we can indeed rely upon. Yes. And there was a knockout blow available if there had been an application made within the 3-month period. And to avoid that, steps were taken. And we say that's perfectly proper.
So for meaningful, we actually unanswerable.
So, remind me what I said.
You said a meaningful amendment.
Yeah.
In fact, to ensure that it was an unanswerable.
No,
amendment.
I rail against that, my lord, for this reason.
You don't need to rail. You can just submit why that's wrong.
My lord, that I'm on television that I'm just using too big a word. I blanch at it because my learned friend says that they have an alternative answer to our application, to our registration. Indeed, before Mr. Justice Miles, they said it was an unanswerable revocation challenge. What we have done is simply shut out, as it were, a simple knockout blow. Not, we say, remove the wider debate as to the revocability of the mark. And that is part of our argument here, because again, that was something that Mr. Justice Miles took into account when considering the overall assessment and where the balance of the prejudice lay. Because it had to be acknowledged that although they had lost this particular point that they could make, in large part, we say, because they hadn't taken any prudent steps to check the register themselves, and either acquire the mark or revoke it. But they are not shut out from advancing another argument that they say is equally good. And that is an important part of the overall analysis that is being made by the judge at first instance. So it's in that sense, my lord, that I stop you over the word unanswerable. Now, that brings up paragraph 4 of the pleading.
Is this on the ground 2 is they should have checked the register point?
Ground 2 is they should have checked the register.
Are you moving on?
No, I'm taking it as part of this issue, because it's in this context they say there's been deliberate concealment. And one of the points that they've made is obviously the point about paragraph 4,
Oh,
indicated, and why they say it needed to be addressed earlier than it was effectively by the proposed amendments. I've actually dealt with it, my lords and my lady, in what we say in paragraphs 19 to 22 of my skeleton. And the first point we say is that paragraph 4, as it then stood, was not intended to convey the meaning it's now been given. Indeed, we say, and the judge accepted, point not appealed, that it doesn't have that meaning because it contains a clear cross-reference to the particulars that are dealing with the issue of joint tortfeasance. And again, I've got myself overexcited in my language, in my skeleton argument when I deal with it, because I've tried to explain why we say this was an ambiguity that my learned friend now points to that we hadn't even appreciated. Because we were simply trying to say, yes, we agree what the second defendant is doing is something for which the first defendant is responsible, and no more.
I mean, just to be clear, Mr. Bramwell, we don't have evidence of when you appreciated there may or may not have been an amendment, an ambiguity in paragraph 4, unless I've missed it. Is that right?
You're right, my lord.
Yeah, sorry. Yeah. Good.
Absolutely. But this ties into my lord's query, which was there having been a point made by the solicitor in his evidence, the claimant's solicitor in his evidence. Why was it not answered in evidence? And that's because we say it wasn't a matter for evidence. It was a matter of argument on the construction of paragraph 4, and it was dealt with as such. And indeed, we say the fact that the argument is made by the solicitor in something identified as a witness statement doesn't turn it into a matter that requires evidence. We say...
No, I understand that narrow point.
Yes.
But the wider point is just simply the absence of evidence in support of an application for an amendment.
Indeed, my lord, and you've made that point.
We've
I've
been
answered it
over
to
that.
the
I mean,
best.
obviously, the paragraph 4 point is part of it, but that's a very narrow bit of it, I think.
Indeed, my lord. But we understood from my...
Anyway, you
notes
say
important
that wasn't a question of evidence, that was a
Indeed.
matter of argument.
that it wasn't intended to bear the weight that it was then given. And as we say, Mr. Justice Miles accepted our argument on that point.
And just to be clear, your argument was that you accepted it needed correction after 15th of March, but waiting until you did it was fine.
I accept, but no, my lord, let me break it down. First, I say it doesn't bear the meaning that my learned friend puts upon it.
Okay.
But I concede that if it had that ambiguity to it, then inherently it became inaccurate by virtue of our having a licence on the 15th of March, and therefore there would have been an argument to say that it needed to be corrected at that point. That discussion again was one that I had with Mr. Justice Miles, and the answer to it is the same as the one that we've given already, namely that we were going to amend to introduce the counterclaims, and as we did so, their issue would have disappeared. But, my lord, because there was no appreciation that there was such an ambiguity, there was no reason to think that there needed to be a step taken in March. It's only something that's arisen as a point of argument subsequently. And that's why I say it's rightly dealt with as a matter of argument and rightly accepted by Mr. Justice Miles as such, and there is no appeal against that finding. My lord, can I turn to unreasonable burden?
This is again in the context of checking the register.
Rightly so.
Yeah.
My learned friend, as I understand it, says it would be an unreasonable burden upon a party to have to check the register every time. We say the requirement is not that they must clear the register, but simply that they should consider whether to do so. And here it appears the claimants didn't even take that elementary step. There's no basis beyond assertion for saying it be onerous. My learned friend says there are hundreds of thousands of marks on the register, but there aren't going to be more than a few, if any, that are relevant in this sense. That is because necessarily the marks in issue are those that are the same or similar for goods or services that are the same or similar, and that's inherently a small or likely a non-existent set, precisely because the IPO and other trademark owners try to prevent such overlaps from occurring. And my lord will recall that I railed against the idea that this was an unusual case, but I did accept it was unprecedented. And it is right to say that we are not aware of any other occasion on which a party has been able to acquire a mark as we have done in order to deploy it in the way that we have done. And that, we say, is a reflection of the fact that it's very rarely the case that there is a mark that fits the bill in the sense that it is applicable, available for sale, and not already under attack by a prudent claimant. So the ad terrorem argument, again one that was made to Mr. Justice Miles and rejected by him, has no basis. Now in this context, my learned friend at paragraph 6 of his supplemental skeleton refers to the Walton case, judgment of Lord Justice Arnold. We say Walton is addressing an entirely unrelated issue. There the issue was one for a defendant who was seeking to rely honest concurrent use. The challenge that was made was to the honesty of the defendant on the basis that it should have checked the register before commencing its own activity to ensure it didn't infringe. You say that's an entirely different context to the point we are making now, which is about the true nature of the prejudice to this particular claimant by the steps we've taken and its role in that prejudice arising. In that case, the issue is whether the defendant had freedom to use a mark, its freedom being predicated on the existence of a defence, one of whose elements was honesty. And it was in the assessment of that question that the issue of review of the register arises. In the present case, the point about the register arises, as I say, as an answer to the suggestion that the claimant has suffered prejudice and how. Paragraph 7 of their supplemental skeleton, they address a footnote in paragraph 26 of my skeleton. There we are arguing that the claimants are wrong when they say that the judge erred in his understanding of the significance of the register. We are pointing specifically to the passage in the final sentence of paragraph 69 of the judgment. My learned friend spent a little time on that this morning because he seemed to suggest, and here he referred in fact to the consequentials judgment at 17.2, that Mr. Justice Miles was thinking only, when thinking of the register, about whether you could tell who was using it, the mark that you found. Whereas you can see from the end of paragraph 69 that Mr. Justice Miles is well alive to the point that whatever the status of the mark on the register, it could be acquired by another party who did begin to use it. That's why, my lords, my lady, I've made such a point about the inherent relevance of the mark. As I've explained in paragraph 36 of my skeleton argument, this reference here is a complete answer to the suggestion that Mr. Justice Miles didn't appreciate what was shown on the register or its potential significance. And we say that the point we make in my footnote, namely that the IPO itself makes precisely this same point on numerous occasions, that a mark can always be acquired or used by another party, is to make the same point that the judge does. And my learned friend says at paragraph 7 of his supplementary skeleton that this is a bad analogy. He points to section 46.3. And we say with respect that the argument in our footnote is not a bad analogy, but an exact one to the point we are making. It's not intended to meet the entirely separate point about the effect of section 46.3. Now, section 46.3 is the proviso, use within 3 months, etc. My learned friend suggests that section 46.3 is there to protect other trademark users by giving them a 3-month window in which to challenge a mark. We say that's not right. It's not there to protect trademark users by giving them fair warning of resumed use. If that were the intention, then the Act could simply and straightforwardly have provided that you needed to say if that's what was going to happen. Register it. And it obviously has given consideration to what matters need to be registered. This isn't one of them. We say section 46.3 is simply there to address the inevitable possibility there'll be discussion before revocation, such of the kind, I see you aren't using this mark, and we buy it off you. No. Okay then, well, we'll revoke it instead. And indeed, my learned friend Skeleton effectively acknowledges that section 46.3 is not there to protect other trademark users in the way he suggests, because he can only say in his skeleton that it provides some protection. In other words, that the result he's looking for is simply a side effect in certain circumstances of its primary purpose, one that does not apply in this case through no abusive action of the defendants.
Mr. Brownworth, I've led a sheltered life. I've never come across a party to a trademark case
Yes.
doing what your client has done in this case of acquiring a mark using another shell company or something to disguise its ownership to avoid the 3-month period effect. Have I lived a very, very sheltered life? Is this a common thing nowadays?
Well, my lord's raising 2 points there. One is the use of a shell company, if you may, an agent, and the other is to do so in order to protect during the
Indeed,
3-month
and
period.
it's the combination of the two is what I'm interested in.
I say you have led a sheltered life, my lord.
All right.
Indeed, one of the reasons is that it's commonly done, I've given in my skeleton argument, which is that you're concerned that third parties will try and swoop in and acquire the mark ahead of you, or that the owner of the mark will demand an excessive price if they know who the true purchaser is. For example, a large company like Apple, if it wished to purchase iCloud as a trademark, and this is a hypothetical example, from somebody who owned it, the owner of iCloud might demand a very different price from Apple than it were if my Lord Justice Birss said I was interested in purchasing iCloud. That is one of the reasons.
Yes,
But it is a
I've
perfectly-
not led that sheltered life. That's quite common. I don't know.
But it's
that
also
wasn't the question I asked you, Mr. Brown.
Perfectly sensible reason to do it as we have done in this case, and again I've made this point in my skeleton argument, in order to ensure that you have an opportunity to make the mark good by use without having to endure a premature challenge. My lord asks me that. Well, my lord, I'll move on.
Yeah.
What I do say, my lord, and I think I've made this point already, is that I accept this is unprecedented in this sense. I'm not aware of any case where anyone has managed to do what we've done here before. And I say that that's because it's very rarely the case that you're going to find a mark of this kind available to you. That's one of the answers that we give to this idea that there's some massive burden that follows from this.
Yes.
It just doesn't happen very often. We've been lucky on this occasion to be able to avail ourselves.
Thank you.
My lord, in doing so, I've answered the next point about policy considerations because we say the Act has given consideration to what needs to be identified, what needs to be registered. This isn't one of them. And secondly, the ad terrorem idea that this is going to create an unfeasible burden on other parties is groundless. Therefore, ground 3, my lord. I can deal with this quite shortly because it's come up already in opening and in my lord's questions to me. This is the point about the equitable ownership. We say that it makes no difference to the judge's analysis whatsoever. As you've seen from the transcript, he was live to the question of the equitable ownership, to its significance, namely that the 250 mark had a potential relevance as a defence at an earlier stage, and expressly references that earlier date and its potential reference in paragraph 58, and we say it's then swept up in his analysis at paragraph 65. It is the same, we say, in consequence, as the idea that we were using the mark with consent, in the sense that...
So same as using the mark?
With consent.
With consent.
In the sense that both potentially give rise to the section 11(1)(b) defence, and that's why we say it's something that the judge had dealt with, was wrapped up for him in what he had addressed as to the potential earlier relevance, and as to which we say he rightly concluded that we were nonetheless appropriate in waiting to bring a comprehensive amendment later on. My Lord, I think given the concession that was made earlier today, I don't need to spend any time on ground 4. In any event...
Well, ground 4 isn't a separate and freestanding ground, and I'm bound to say that's what I'd always understood. So.
Indeed, and my Lord, we've answered it in detail in the skeleton argument. My Lord, there are a couple of paragraphs in the supplemental skeleton which necessarily I haven't had an opportunity to address, so for completeness sakes, if I may, I will do so now. Picking it up at paragraph 8, so I'm now in tab 12 of the core bundle.
Page 120.
Indeed.
Yeah.
This first point, paragraph 8, is tied into that ground 4, and we say, as an argument, it makes no sense whatsoever. That is because we were acting in a way that we understood ourselves to be entitled to do. It turns out that our counterclaim for invalidity was one that the judge rejected, but as he rightly recognises in paragraph 108, we believed ourselves to be entitled to do so.
Right, but is that a polite way of saying that you now accept that the point being made there is right?
No, my
now, although it wasn't. The reason you could have your permanent injunction in your case as you apply to amend, because you were asking for a revocation of their mark, but now that's not in the case. It isn't right that you can get a permanent injunction, they say, because you've conceded that neither party can injunct the other on your case.
It's right that we can't get a permanent injunction. That is a question of relief, not about the validity of the counterclaim for infringement as such.
Right.
It's a partial defence, so we say, to a particular aspect of relief, so we say the counterclaim for infringement itself remains entirely valid. That's the point that the judge himself addressed in the judgment. The relevant paragraph, my lord, is at paragraph 101. Maybe I could ask you to turn it up, my lord, because, as I say, one of the quandaries I faced is that because there's nothing new being advanced by my learned friend, Mr. Justice Miles has already answered better than I can, and more succinctly and elegantly than I can, all of the points. So you see at paragraph 101, I'm on page 53, he's dealing here with the effect of the counterclaim and of the defence under section 11.1. And he explains, with material that was given to him in writing by our side, at first, that there is a gap, because one of the marks they rely on for that section 11.1 defence is the stealth VR mark. That's the earlier mark in time. And it's not clear that what they're using is that stealth VR mark. Mm-hmm. Second, it wouldn't be available prior to the filing date of the 24th of March 2020. And so in that respect, the counterclaim for infringement is still valid prior to that date. And perhaps the easiest thing to do to show you in that regard, my lord, is to take you to one of the questions that we were asked on precisely this point, which can be found in the supplemental...
I know it's, I'm sure it's me. What I thought I was asking you about was your claim for an injunction.
Yes, my lord.
So far you haven't mentioned that, you mentioned other things.
And I may be at cross purposes. We can't get a permanent injunction, but the issue that my learned friend is raising is whether or not there was any purpose to the counterclaim for infringement at all.
Right, I understand, okay, well, maybe I should have said more. I understand that there may be a reason to have a counterclaim for infringement even if you can't get a permanent injunction, but I thought the point that was being put against you was a simpler one, that you were asking for a permanent injunction while at the same time saying you can't have one. That certainly resonated with me.
Well, my lord, at the time that we made the amendments...
I understand, and you've explained that at the time you made the amendments that was logical because you were doing something else, but now that the judge has refused to let you do that other thing, it still strikes me as being a legitimate point for your opponents to make, that you're still asking for a permanent injunction, which you're also saying you can't have, unless I'm misunderstanding it.
But indeed, my lord, until they pleaded that defence, I was entitled to ask for it. That's one of the points that we made to Mr. Justice Miles, that all of this was being dealt with without us being told what their answers were going to be to these positions. That position has now been clarified. There was a request made to us, and a response has been given. But it was all, at that stage, my lord, liminal. Once the defence is put in and they plead section 11.1, then it must follow.
I see. So once the defence goes, if you're allowed to make the amendment and the defence goes in, you're recognising that you can't, that you'll have to remove the injunction from your prayer for relief.
For uses of the mark, yes. Yeah. But one of the points that we've made and have made in the response is, first of all, is that we don't admit that what they're doing are uses of the mark.
Okay, well maybe it doesn't matter.
Well, my lord, I don't think it does.
Fine. I won't take up any more of your time.
But we do say it's wrong, because the point is not the one that my lord makes, but rather this idea under ground 4 that the judge had erred at all in allowing us to advance these amendments in circumstances where the counterclaim for infringement, the claim itself, was bound to fall, when their only point is about the availability of a particular kind of relief.
Okay.
And that is why I've made reference to paragraph 108 of the judgment, because it is there that the judge expressly addresses the point. And I've made reference to paragraph 101 of the judgment because he draws out exactly the issue that my Lord has just addressed me on, namely, is there a gap?
Are there any, I'm conscious of the time, are there any other points that go to the heart of the appeal that you want to make by reference to the appellant's supplementary?
My Lord, let me deal with them quickly. Paragraphs 9 and 10, it's a subsidiary argument set out at paragraph 38 of my skeleton that's being addressed here. That the alleged prejudice disappears when you look closer at the provisions of section 46(3). My learned friend tries to meet it by saying that we're wrong, but we say the very fact that there is an argument on this issue is one of the reasons why Mr. Justice Miles recognised that the alleged prejudice that they were experiencing was itself a matter of debate. Finally, paragraph 11 of their supplemental skeleton.
Yeah.
This is the point that we have made up front. Namely, that if this argument here made in paragraph 11 were good, it would merely support our argument that there is a tension in the claimant's position when it says they have suffered prejudice in circumstances where they say, in fact, they have an unarguable answer to our new mark, and I've set it out in more detail in paragraph 41 of the skeleton. And the reason I say that does go to the heart of the appeal, my Lord, is this. There is a global assessment required by the court in the exercise of its discretion. All that the law, we say, requires was done. When Mr. Justice Miles looked at the question of lateness, he took into account all the relevant factors, not just isolating out the particular point that my learned friend draws to your attention. But he also considered the degree and nature of the true prejudice to the claimant, which is not, as my learned friend puts it, a lost opportunity to make this application within a 3-month window, but rather simply to be told that they needed to make that application in circumstances when they could have made it at any point from 1996 onwards. And at the same time, in circumstances where they say they have a near unassailable revocation challenge that they can make, so that the prejudice they claim, prejudice of which we say they are the author by inaction, is itself moot. And it is that background against which they suggest that the fair course of action is to deprive my client of a statutory defence that comes with a lawfully acquired trademark. We say nowhere is it explained why the judge was wrong to take this into account, or why it was plainly wrong for the judge, as he expressly says he did in paragraph 17 of the consequentials judgment, to allow this factor to outweigh such prejudice as could be shown to arise from the effect on section 46(3) being removed from consideration. My Lord, for completeness, there is another witness statement of Mr. Stark. In the final 3 paragraphs of that witness statement, Mr. Stark sets out no more, I would say, than what is to be found in paragraph 4 of our pleading. And therefore, when my Lord has pressed me on the question of what evidence there was as to the basis for the amendment and its timing, I've not troubled to take you to it, nor is it in the bundles.
It's not in the bundle.
It's not in the bundles. I don't suggest you need to look at it, my my lord, but I do think it would be
Well,
right for me to say.
it would be for completeness, because the point may have some significance. Could you send that through?
My lord, I could do better than that. I have them here if you would like them, and I can give one to my learned friend. He's obviously seen it before.
Well, he's
nothing-
obviously seen it before, but we haven't if they're not in the
Indeed,
bundle.
my
So,
lord, there's nothing of excitement in it, but I do think
with apologies to my lady and my lord for burdening them further with something that only I may be interested in. We don't need to take up time now, but we can look at
it's
that.
paragraphs 49 through to 51.
If your solicitors would be so kind as to send me an email with a PDF of it, that would be appreciated.
It will be done, my lord. My lord, unless there were any other questions, my lady, those are my submissions.
No, thank you very much, Mr. Rendrith. Yes, Mr. Akins.
My lords, my lady, just a few points in reply, if I may. I start off with the legal questions, and my Lord Justice Birss asked what is the purpose of asking whether an amendment is late. And my answer to that, I think, was anticipated by my Lord Justice Birss, is that triggers an obligation to provide a good reason for delay, according to the principles and the authorities. And that, we say, is squarely in accordance with the modern approach to litigation, that one should be open and not withhold matters to one's advantage to produce later on. And we say that is supported by the exposition of the principles by my Lord Justice Coulson in CIP Properties. And we also say that while we accept that lateness by which an amendment is produced is a relative concept, what it's talking about, what is being talked about there in terms of that concept, is the timeline. And it is sufficient for something to be late on the law that it could have been advanced earlier. So these are disjunctive factors to take into account in paragraph 19a. And so in this case, because it is now common ground that at least part of these amendments could have been advanced earlier, then the amendment is a late one, and that triggers the obligation to provide a good reason for the delay. And in that respect, I now note that it is common ground that the section 11(1)b defence was available as at 28th of January 2021, even on my learned friend's case. So again, things have moved on even further. And that is, you will appreciate, before the defence was filed in this case. So the arguments on proportionality don't even get off the ground, because it's said not to be proportionate to do two amendments after the original defence had been filed. This wouldn't have involved two amendments. It would have involved including the section 11(1)b defence in the original defence, and then, on my learned friend's case, one further amendment whenever they took legal title. So that reason, the proportionality, completely falls away given that concession. One point on paragraph 4 of the defence. It was in my submission conceded that that was, by my learned friend, that was inaccurate as at 15th of March 2021 in the hearing below. And I've given the references for that at footnote 24 on page 13 of my permission to appeal skeleton. it wasn't qualified, say, in the way that my learned friend suggests. Thirdly, my learned friend talks about the prejudice. Well, my remaining points can be taken together, I think. My learned friend says, well, we haven't taken into account the prejudice to the respondents in refusing the amendment. And I say that's not right. That was the last aspect of my submissions in opening. And for that purpose, I took your lordships, my ladyship, to the last paragraph of the principles in CIP properties. Say, yes, that's a factor, but it's but one factor, and it is neutralised if that is a factor of their own making, of the amending party's own making. But that leads on to the most important submission that my learned friend was making, which, if I have understood it correctly, it is that the prejudice in refusing the amendment is to disallow the defendants from running this precise scheme that they developed, which involved concealing, we do say it's concealment, their interest in the mark, with the express purpose of getting through the 3-month period in section 46.3 and thereby avoiding a revocation claim. So, if I've understood it correctly, my own friend is being completely frank with you that they should be entitled to do that, and that the prejudice is not to allow them to do that. It's not to allow them to make the amendment so as to allow on this mark, but to allow them to rely on this mark. It's to allow them to make the amendment at a time which enables them to deploy this mark to its maximum effect, and to delay the amendment so that this mark can be deployed to its maximum effect. And that is a stark proposition, we say, and that, we say, is directly contrary to the rules on amendment, the overriding objective of modern approach to litigation, because it is honestly and expressly using the amendment system to their advantage.
Using the amendments as a
amendment system to their advantage. So withholding part of their
system. Sorry, yeah.
and deploying it at a time that is of most advantage to them. And that should be that.
Thank you very much.
Sorry, just one further point on concealment. We say that the concealment is established by one fact alone, sufficient. They didn't register the license from NCL to the respondents on the 15th of March. Those are my submissions.
Well, thank you very much, Mr. Akins. Thank you very much to both of you and to your teams. It was an extremely interesting matter. We will obviously reserve our judgments. You will get them in draft in the usual way. That is in order that you can correct our spelling and our grammar. It's not an opportunity to re-argue the appeal. The drafts will be sent out with a clear warning as to their confidentiality, and in the light of recent events, as you're probably both aware, you can take it that warning has neon lights and possibly even an alarm going off. So only the designated people can look at the draft, and that has now assumed a real importance. So So please ensure that that's what happens. I'm afraid I can't promise when you'll get the judgments, but you will get those in due course. Thank you all very much.